Next case is Mario Vitelli and Carol Bartholomew versus Hager. Reset the timer. How much time would you like for?
5 minutes would be plenty, Your Honor. Thank you.
5 minutes? Okay, whenever you're ready.
Thank you, Your Honors. Good morning. May it please the Court, my name is J.B. Ross. I am the attorney for the appellants here. Dr. Carol Bartholomew is in the courtroom. As you know from our notice, her husband, Mr. Vitelli, passed away during the pendency of the appeal. Your Honor, we asked for oral argument today because it's kind of an important case. They all are, of course, if they're in court to start with. But this one in particular, because we are dealing with a statute that allows a court, by judicial opinion, to take land from one person who lawfully owns it and allows another to use it. And land is unique. Land has always had a special place in our jurisprudence. And if we as a court, we as member of the court system, attorneys and judges, are going to do that, I think we have to make sure we do everything right. And in this case, we're sadly very far from having done everything right. The case was decided on summary judgment, and the only summary judgment evidence offered, the only one besides outside evaluation on the merits, was the verified complaint. That's it. So what is the
But the oath and the verified complaint, let me find it. Says that they understand the nature of an oath, the meaning of personal knowledge, and having been duly sworn under oath, declare the statements and facts written above are true and accurate based on my personal knowledge of the matter stated, which complies with the rule regarding affidavits, does it not?
It does, Your Honor. So at best, then the complaint becomes an affidavit, and a self-serving conclusory affidavit alone cannot support summary judgment. There's a case law to the wazoo on that. A number of cases are in our brief. There is no more conclusory document than that complaint. If we look at paragraph 8 of the complaint, it says, we want to use the land for one of the authorized purposes under the statute. It doesn't say which one. In fact, paragraph 8 is little more than a copy-paste of the statute into the complaint. Paragraph 9 says, we hemmed in. Again, that's a raw conclusion. Hemmed in by what? On which side? Most parcels have 4 sides. We're talking about 3 parcels. All we have are legal descriptions. I certainly cannot tell from those legal descriptions where each parcel is and how they fit a puzzle.
Do you agree that the complaint adequately alleges the statutory easement?
No, I do not. I do not because the complaint does not allege the absence of a common law way of necessity.
But doesn't it by all the allegations that are alleged in the complaint, it necessarily alleges the statutory easement over the common law easement.
That is certainly what the First District Court of Appeal found in Parham. I personally disagree. I think the first DCA had it wrong on that. I think, especially on matters like that, you shouldn't plead by implication. You should actually expressly plead all of the elements of the cause of action. But even if we go with Parham, Your Honor, it's interesting to remember how Parham ended. And I'm reading from page 136 of the Parham case, which said that the plaintiff there met all the elements for statutory way of necessity, save one, proof of the non-existence of a common law way of necessity. Therefore, on this record, the trial court could not grant a statutory way of necessity. No evidence was presented to show that a common law way of necessity is not available. So in this case, even if we go with Parham, even if we say, sure, you can plead it by implication, the only evidence at summary judgment was a complaint that did not plead it. Therefore, there was no evidence at summary judgment that a common law way of necessity did not exist. And without that evidence at summary judgment, on the record and under Parham, the court could not enter summary judgment in favor of the plaintiff. And again, as of the other elements of the statutory of necessity, I totally agree they were pled. They were averred, but they were averred in conclusory manner. Does that survive a motion to dismiss? Absolutely, none was brought. Is that sufficient evidence to support summary judgment? I respectfully submit to Your Honor that it does not. Just saying we're hemmed in without more, that is not enough proof to support summary judgment. Just, it is very different from the Mesa case, for example, Mesa v. Peace Creek. There, the plaintiffs had brought evidence that there was a swamp and that the swamp prevented access, and so they had to go through the dominant parcel. That's the kind of evidence that support judgment in a statutory way of necessity cause of action. Just saying we're hemmed in is not enough. Just saying that the defendant's land just happens to be the most practical way to access a roadway without proving it, just saying it in a conclusory manner, that does not support summary judgment. They had to make a prima facie case. We were going to the very basics of summary judgment here to hold Vitelli and Landers v. Milton. They had to make a prima facie case, present actual factual evidence. The standard is no genuine question of material fact. The standard is not no genuine question as to whether they averred every element of the cause of action. And they did not bring any fact, disputed or otherwise, to establish a prima facie case to support summary judgment. Not that they were landlocked, not that there was no practical route, not what the nearest practical route would be, and certainly not that it wasn't even pled that they did not have a common law way of necessity. They also, on the question of attorney's fees, never pled and never argued that the defendant's conduct was unreasonable. Under 704.04, only when the defendant's conduct is unreasonable does it warrant award of attorney's fees. We cited a number of cases in our brief of what unreasonable conduct is or has been found to be in that context. I'm not going to rehash them. But we're very far from that. There was no allegation, no fact presented that would bring us close to unreasonable conduct. And even regardless of that, it wasn't pled. It wasn't argued. Even if you read through the whole transcript of summary judgment, nowhere do they say, Your Honor, the defendant acted unreasonably, therefore we'd like fees. So awarding fees without a finding of unreasonable conduct was definitely error. The second general ground for our appeal, Your Honors, is that procedurally this case occurred in a way that I find very disturbing, to the point that I think it raises due process and the Sixth and Seventh Amendment questions. If we take a quick look at what happened in chronological order, on April 30, the defendant's attorney was granted their motion to withdraw, and the defendant was given 30 days to find another attorney. That put us to May 30. On May 15th, knowing that the defendant was unrepresented at that time, the plaintiff rushed their motion for summary judgment with nothing but a complaint. Zealous representation or sharp tactics, I'll let you be the judge of that. On May 26, The defendant, particularly Carol Bartholomew, one of the defendants, Dr. Bartholomew, brought a motion asking for extra time to find an attorney.
But they had already contacted six attorneys.
That's correct.
And they were unable to hire somebody.
That is correct.
How do we know that in the next 30 days that she'd be able to find an attorney? When do you cut that off?
That's a fair question, and I don't know that there's an easy answer, and I no disrespect to the trial court there. There is no easy answer. But you have a motion that says, Your Honor, I'm not ignoring you. I'm not ignoring the court. I'm not making a mockery of things. I've really been looking. I've looked for 5. I haven't been able to come to terms with them. It's difficult for me to do that because my husband has terminal cancer and he's dying next to me even as his case is going on. May I please have a little bit more time? Because I'm a doctor. I'm not a lawyer. I know nothing. I don't know what to do. I don't know when to do it. I don't know what the proper procedure is. I don't know what evidence is. I don't know when I may or may not bring my witnesses. I just don't know. I need a lawyer to take this case. And the court says no. The court says no. I understand the court has discretion to manage the litigation. But in this case, I think we're getting to a point where the right to be heard is lost. The right to be heard is more than the right to be present in the room during the summary judgment hearing. It's more than just the right to be there.
She was given the right to be heard. She was given notice. She was given an opportunity to be heard. Now, whether or not the trial court considered the evidence that she had to present is another story, but she did have the right to be heard.
The right to be heard at a due process level is, under Dobson, the right to be heard meaningfully, in a meaningful way, at a meaningful time. I subject to Your Honor, she was not heard in a meaningful way. She told the court, in order for me to be heard in a meaningful way, I need a lawyer to present my case. Just give me a little bit more time. And she was denied that, so I don't think she was...
The trial court does have discretion on how much time to give. So on that issue, we would have to find that the court abused its discretion.
Correct, Your Honor. You would have to find that... In fact,
there's no, as you admit, there's no hard and fast. You give them 30 days or 60 days or 90 days.
There's no hard and fast. It's an abuse of discretion. I'll give you even more leeway than that. Not only would you have to find for the constitutional aspect to come into play that she abused her discretion, but that abuse of discretion restrained the defendant's ability to retain an attorney and to be represented by counsel when they very clearly wished to do so. It's a high bar. I don't disagree with you on that at all, but I think that bar is satisfied in this case.
But the court had knowledge at the time, correct, that she had spoken to 6 additional lawyers and no one was willing to take her case for whatever reason.
Well, I don't know what the record does not say why the court denied the request, the motion for an extension of time. It's a single-line order, as they often are. So we don't know what the court was thinking. We do know from the transcript at summary judgment that Dr. Bartholomew asked, and you can nearly hear her voice in the transcript, do you know why I don't have a lawyer? And the court says, no, and it doesn't matter. You just don't, and I have to hold you to the rules of this court. Part 2 of that statement is 100% absolutely true. Part 1 leaves you to wonder how much attention the court paid to the motion for an extension of time, because 4 days later, the court did not seem to remember why Ms. Bartholomew was not represented at this particular time. The motion was denied on June 7th. The summary judgment hearing was on June 11th when the court said, no, I don't know why you don't have a lawyer. So I am questioning whether the court took the issue of representation, which is material to due process, sufficiently seriously. And if the court did not, the trial court did not, then there is abuse of discretion, and there is abuse of discretion to the point that it interfered with the defendant's ability to be represented by counsel, and that implies due process, the very fairness of the proceedings, and its fundamental error that would require reversal. A minute short, but I'll reserve the rest of my time for rebuttal.
Reserve the rest? Okay.
Thank you.
May it please the court. I'm Lawrence Calloway of the firm of Klein & Klein LLC. We represent the Appellees, Emil and Carolyn Hager. We believe it's clear from the record that there was no genuine issue of material fact and that Mr. and Mrs. Hager were entitled to summary judgment in their favor as a matter of law, and accordingly the entry of summary judgment in their favor by the trial court was proper and should not be disturbed upon appeal.
What about all those long line of cases that say conclusory self-serving statements are not sufficient to shift the burden to the party opposing summary judgment?
Your Honor, we would submit that the statements are not conclusory. In this case, they're simply statements of fact, the statements of the fact that they're required in order to complete the elements for the cause of action. There was no legal conclusion, just a statement of fact that for each one of the elements, including the fact that they were hemmed in, shut off, which would include not only not having access to a dedicated road right-of-way or prescriptive easement, but also an implied easement over property of others. And
if they wanted to do one of 3 or 4 things all provided in the statute. I mean, it's basically just them swearing that the statutory language included in the complaint applies to them and is true.
But they have the factual basis for obtaining a
right, but in terms of laying that factual basis out, they say, here's what's wrong here. Mm-hmm. Here's why we need a remedy. But in terms of saying, there's a swamp, there's a river, there's a wall, whatever it is, in terms of actually facts like you would expect at a trial, the affidavits didn't really lay out facts like that, did they?
No,
I'm sorry, the verified complaint.
The verified complaint laid out the basic facts required to state the cause of action.
Well, it set forth the elements. There's really no facts. It doesn't say how the property's hemmed in or anything like that, right? It's just, like Judge Edwards said, sort of conclusory allegations from the statute.
It pled the basic elements. Yes, Your Honor, that's correct.
And then attached to the complaint were the legal descriptions of the 3 properties, correct?
Yes, Your Honor.
It's ultimately still a finding that has to be made at some point, right? I mean, you also allege in the complaint that your clients are entitled to attorney's fees. They swore that's true as well. Does that mean they automatically get their attorney's fees?
No, it's based upon the fact, Your Honor, that the record reflects, the only things that are in the record reflect that the appellee's property was hemmed in, that was not accessible and therefore would be useless unless they had the access. There's no evidence introduced by the appellants that the incursion across the 60-foot strip of their property would create any inconvenience or any...
I'm not getting to whether it's reasonable or not. On the merits of the attorney's fee, my point is, just because it's in the complaint and your clients verified it, doesn't mean it's true.
I mean, doesn't the trial court have to make some sort of finding of unreasonableness in order to grant fees in the case? And I didn't see any findings with regard to unreasonableness in the final judgment.
The only thing would be that there would have to be an abuse of discretion in the awarding and based upon the weighing of the facts between the potential loss of use of the appellee's property and the lack of any evidence of any inconvenience or disability imposed by the appellants ended up creating an unreasonable situation for denial.
Did you plead that their conduct was unreasonable?
We pled basically the facts that by themselves showed it was unreasonable because it renders...
Is the word unreasonable in your complaint?
No, Your Honor, it is not.
Nor is statutory 70404. You don't cite to the statute either, 704.04. You cite to statute 704012,
Yes, Your Honor.
but not 704.04, which is the statute, the statute that talks about fees. And I will give you, not pled, but in your wherefore clause, you do mention unreasonable refusal in your wherefore clause, but you don't cite the correct statute, nor do you make any allegations of unreasonableness. Just that your only allegation with regard to that is that they requested the defendants allow them access and they denied it.
And it becomes unreasonable because...
Well, you have to need to prove unreasonableness. Just because they deny access doesn't necessarily mean that it's an unreasonable denial. I mean, if they have a defense to it, that such as that this is if there's a defense that it's, there's just a common law right of access as opposed to a statutory right. I mean, if that's their argument, or if they have some or that there's, that they actually do have ingress and egress, that the road, the road you're claiming is the nearest road isn't really there are lots of things they could allege to show that their denial was unreasonable if it got to that point, but there's nothing in the complaint that shows why you think that their actions are unreasonable.
Again, Your Honor, we believe that the complaint sets forth the basis for it by showing that we have a parcel of land that would be rendered unusable and totally, essentially worthless if they did not have access. We have no contrary evidence by the appellants that the access sought would in any way inconvenience them, and based upon the facts that are in the record, the potential loss of value of the property, the lack of any inconvenience on behalf of the appellants, the weighing of those elements shows that to be unreasonable.
What was the evidentiary basis for setting the value of the way of access?
There was a affidavit of market value by a licensed appraiser that was introduced into evidence as part of the summary judgment. Attached to the affidavit was full details as far as the location, comparable values, anything else in the surrounding area.
In terms of proving up that there was no common law way of access, what proof was there of that?
The only proof that's in the record was the statement, or the verified statement by the appellees that they were hemmed in, which would, as I stated earlier, would include the lack of any other access at all. The court found that to be sufficient and specifically held in the final summary judgment ruling that there was no implied access over properties owned by others. The court did not require us to state in sequence that there was no adjacent dedicated right-of-way. It did not require us to say there was no prescriptive easement. They felt the court was satisfied that that was all encompassed within the single statement that the property was hemmed in by either properties or other improvements of others as required by the statute.
If one of the essential elements is that they're not entitled to a common law easement, you're relying on a verified pleading that doesn't allege that element, where is it established? I mean,
Again,
just by implication?
Again, as stated in our brief, that's encompassed within the assertion that it is the property is hemmed in. It's hemmed in, and one of the ways it's hemmed in is that there's no common law way of necessity. And again, the court found the overall assertion in the verified complaint to be sufficient and specifically found in its final summary judgment that there was no implied way of implied easement over properties of others. If I may, we said the Vermans and Mr. and Mrs. Hager's verified complaint established a prima facie case for the statutory way of necessity under the statute, and that put the burden upon the appellants at that point to come up with some information or some admissible evidence that would at least create an issue of a genuine issue of material fact. For example, if they had on the issue of the absence of a common law way of necessity, if they presented admissible evidence showing that there had been a prior common ownership of parcel A and another parcel, then the burden would have been back on to the appellees to show that there was no common law way of necessity. That was not done.
Well, they did in fact raise by affirmative defense that the property is not hemmed in and that there was an implied easement over other properties. Was it incumbent upon your client then to somehow refute the affirmative defenses?
Again, the only thing that, going back to the basic cases that say that the summary judgment is decided upon the evidence and not on the pleadings, we introduced, the only evidence that was introduced was the verified statement that it was hemmed in, which would be a comprehensive statement. It was hemmed in by all, in every sense of the word. and therefore the burden would be upon the appellants to bring forward some contrary evidence, something to show that there was some possibility of another either a prescriptive or a way of necessity or something else, and then the burden would have been back upon us to.
Did you oppose their request to have additional time to retain counsel?
No, Your Honor, we did not. And just for clarity's sake, I would like to point out, Your Honor, the only facts that were recited in the motion the motion for a continuance was the fact that they had spoken with 6 attorneys and none had retained or none had agreed to take on their case. There was no mention of the appellant's husband's medical condition at that time. They did file on Friday before the Monday hearing a motion that made mention of that, but apparently, at least according to the transcript, that motion never made it to the trial court's bench. It was not raised by the appellant upon argument at the trial court. Matter of fact, if you go back and look at the transcript, the only objection that she raised toward the end was not that she was unable to prepare for the hearing because of the illness of her husband, but that she only had 3 weeks to respond to a motion for summary judgment, which is the prescribed time under the rules. And as the court properly pointed out, that even as a pro se defendant, she had to apply by the same rules that anybody else would. She never raised her husband's illness as a means of preventing her from preparing. As a matter of fact, she prepared extensively, prepared a great deal of evidence that was all of which was inadmissible, but it never stopped her from preparing. Again, with the attorney's fees, as we stated, the idea was that when you weigh we have a very sparse record in this situation. The only record is that which was put into the record by the appellee. And again, the evidence is on the face of the situation that you have a situation where a parcel of property would be rendered unusable, invaluable by the lack of access, and if they were not granted a statutory way of necessity, and
Or were they going to use the property for residential purposes?
residential or agricultural, it's part of a horse farm, and
Timber, were they going to raise timber and cut timber?
that was one option. The Haggers are elderly. They're going to use it for the best uses, which is either, at this point, it's part of a horse farm, and that's what they're planning on using it. They may at some point use it for a residence, a separate residence. That would be permissible under the statute, but they can't do it. They can't do anything with it right now because they can't get to it, and that's what they're just trying to do: be able to get to it, and they're willing to limit the uses to the intended purposes or the permitted purposes under the statute.
But the court in this case has sort of taken at least the use of one person's property, given it to another, only because that other person says we need it. There's no proof that they need it. They just say they do.
They have a
Is that
sworn-
sufficient to take ownership or an easement over your property because your neighbor wants it?
Again, Your Honor, we have, again, it's not just someone saying it. They have a verified complaint.
Well, verification is not under penalties of perjury. Doesn't state what their basis of knowledge is. They just said, we read it and it's true. I mean, that's not a lot.
They also say it's in the verification, they say it is under oath, Your Honor.
Well, they say they're familiar with what an oath is, but it doesn't say we know the penalties of perjury. It doesn't say how we know it's hemmed in. It doesn't say we've hired a surveyor, we've done anything. It just says we're hemmed in. As this whole thing started out, Judge Edwards said that's about as conclusory a statement as you can get.
But again, the statement is based with their knowledge, based upon their personal knowledge and with full knowledge of what a sworn statement is, and which would include the penalties for perjury. Your Honor, again, the situation simply is, Your Honor, we have a situation where the appellees fulfilled the requirements to establish their case. They established a prima facie case. There was no contrary evidence or anything to put the facts in issue by the appellant, and the court properly entered summary judgment in that case.
Was any proof offered that your clients offered to pay the defendants for the right to use the property?
No, Your Honor, there was no evidence on that point.
In the absence of any evidence that they offered to pay, how could it be unreasonable for them to refuse to just say, yes, go ahead, whatever vehicle traffic you want for residential, agricultural, livestock, timber cutting, bring it on, no problem, we don't care if you pay us or not? How's that unreasonable to go, are you going to pay me?
There was no inquiry as to payment by the appellant. There was just a flat out, I'm locking the gates, you don't have access.
Where's that in the record?
The statement that they refused access. If the appellants had produced evidence that they had the ability to introduce evidence stating that they would have made access available if they had been compensated, that would have created an issue. And the net result of a statutory way of necessity is we compensate. We acknowledge that we were going to compensate by going for the remedy we elected. I have none. Any other questions?
Do you have any questions? Moving up. Thank you.
Thank you, Your Honors. It looks like this might turn around what is conclusory. Appellees have admitted all they have is the statement, "We're hemmed in." My esteemed colleague calls that a fact. I respectfully disagree. The facts would be what hems us in, like the swamp in Masser, hemmed that property in. What is to the north? What is to the south? I don't even know where my client's properties are compared to theirs. Today we heard for the first time, roughly 7 minutes ago, that they want to use the property for a horse farm. That's a fact. It was never in front of the trial court. Just saying we want to use it for perhaps one or the other of the statutory purposes that we copy-pasted into the complaint. That's not a fact. So there was no prima facie case. Therefore, we were under no obligation to present contrary evidence. That came up several times during response, that there was no, quote, contrary evidence presented. There was none to present. There was no prima facie case presented to start with. The appellee also stated that, indeed, the court did not require them to prove specifically, separately, the absence of a common law way of necessity. Under Parham, which they rely on in their brief, that is error of the trial court not to have required that. So that essentially right there requires reversal. The attorney's fees, I think the question was made even clearer again during the response. Appellees admitted they did not plead the grounds for attorney's fees, neither the statute, not the nature of the so-called unreasonable conduct. There was none. Refusing access is not unreasonable. Refusing access is a property right that you have when you own a piece of real property. It's Law School 101. It's part of the bundle of sticks that law professors always talk about. I'm going way back here, further back in time than I care to admit. But refusing access is not unreasonable, and nor is litigating a case when your neighbor then comes and sue you for that access.
Well, it can be unreasonable, but it's dependent upon the facts and circumstances.
Absolutely, it can be, but in itself,
It's not per se
it is not unreasonable. Litigating in itself, thank you, Your Honor, in itself, litigating that case would not be unreasonable. Finally, on the due process part, we may not have to go there. Courts do not address constitutional issues if they don't have to, and I think that the total absence of facts and proof in this case would be enough for reversal. But my esteemed colleague pointed out, as a lower court judge did, that pro se litigants must play by the rules. That's exactly right. She wanted a lawyer so bad. She doesn't know the rules. She knows she doesn't know the rule. She knows she's at a horrible disadvantage to be meaningfully heard. So she wanted an attorney. She asked for additional time. She didn't get it. I think that raises constitutional concerns in this case, Your Honor. Unless you have any more questions, I respectfully request that the summary judgment be reversed. Thank you.
Thank you. All right, we're going to take a break at this time, and if any of the attorneys would like to meet us in the Lawyers Lounge for coffee, you're welcome to do so. Recess.